Hello, I am Rangarajan. Today I am going to discuss about that Adhoc arbitrations. What is Adhoc arbitrations? So Adhoc arbitration is a dispute resolution process where parties instead of institution so their own rules for arbitration, including selecting the arbitrators, determining the procedures and arrangement the administrative support. Means there is no involvement of the institution here, but at the same time, rules for they will set their own rules for arbitration, including the selecting arbitrators and determining the procedures and arranging the administrative terms, support. It makes the process more flexible and potentially faster and sometimes cheaper as it avoids administrative fees when two companies involved in a dispute agrees on their own arbitrator and use pre-existing rules like the unilateral arbitration rule structure the proceedings rather than submitting to a body like International Chamber of Commerce. So the main idea of the ad hoc arbitration is there to select their own arrangements and also procedures and also administrative support to complete the process. What is ad hoc arbitrations? It is a non-institutional arbitration where the parties are in control of the setting up of the entire process. Here, the parties must decide on every aspect, including the number of arbitrators, how arbitrators will be appointed, the procedural rules to be followed, the applicable law, administrative support. The number of arbitrators means they may ask for the both of them agree for the one single arbitrators or multiple arbitrators or third arbitrators also they can arbitrate like that. How arbitrators will be appointed? The arbitrators will be appointed based on the no, there is no conflict of interest between the parties. So he must be a neutral person. So it has to be very carefully. We have to see that the procedural rules. What are the procedure? How we have to follow the rules and regulations? Applicable law. The law to be applicable in if in India it is a state wise it has to be applicability. If in it is a foreign, we have to apply either Indian law or the Singapore law or US law like that. We have administrative support. There should be administrative support for the ad hoc arbitration, non-institutional arbitrations. So what is the ad hoc arbitrations? Two companies agrees to process. Two construction companies have a dispute over a building project. They agree to resolve it through ad hoc arbitration. They jointly select a mutually respected construction expert as a sole arbitrator and they follow the arbitration rules to govern the process. They will handle their own scheduling, document exchange, and other administrative tasks. This is the one of the example. So example two, the another examples, a company has a contract that specifies the arbitration but does not name a specific institution. If the parties cannot agree how to proceed, a court may step in to appoint arbitrator, but the arbitration continues to be ad hoc manner as the parties will still need to agree to procedural rules for the arbitration itself. The fallback mechanism also is another example for the ad hoc arbitrations. The third use supportive institution. Two parties use a non-administrative arbitration but have a pre-agreed fallback support mechanism. They agree to follow the unilateral rules but also agree to have an arbitral institution. Suppose Singapore International Arbitration Center or an appointing authority. In case they can't agree on arbitrator themselves. This is like that supportive institution also they can take for the ad hoc institution arbitrations. Cost effective ad hoc arbitration is certainly less expensive than the institutional arbitration, as there are no administrative fees associated with an institution. Parties looking to minimize the cost may choose the ad hoc arbitration as more cost effective option. It is a cost effective option. Ad hoc arbitration is a cost effective option. Flexibility. The ad hoc arbitration offers parties to flexibility to tailor the arbitration process. So the rules they can flexibly they can, and more also and also how we have to approach the arbitration, and also timeline. Everything should be decided. The there are a lot of flexibilities in that work arbitrations. Confidential arbitration. Adhoc arbitration offers a high level of confidentiality as the arbitration not administered by an institution. This can be important for parties seeking to keep the details on their own dispute private. So there is a private, the big family disputes are coming under the Adhoc arbitration, so that they won't go to that institution or the high court or anywhere. They have to appoint their own arbitration and consult and complete the process. Sovereignty advantages. Parties who are concerned about the maintaining the sovereignty over the arbitration process may prefer the advocacy arbitration. Means it allows parties to shape the arbitration in a manner that respects the autonomy and avoid institutional control. Here, the advocacy arbitration, there is no institutional control will be applicable. Quick resolution advantages. Adhoc arbitration can be faster than institutional arbitration, and the parties have greater control over the process. This can be advantages for parties seeking a quick resolution to the dispute. Means they are having the full control over the process. So the quick resolution will be happen. And unlike the institutional arbitration, there are their own process, procedures, and other things, and everything will be take place. So there are advantages. There are disadvantages also there. Administrative burden. The administrative parties or arbitrators are responsible for administrative tasks which can be time consuming. Complexity and uncertainty. The lack of standardized rules can lead to uncertainty, disputes over procedural matters, potentially causing. Unless you have to have a standardized rules, it is very difficult to complete the ad hoc resolutions, ad hoc arbitrations. Put the potential for delays. Resolving the procedural times can be a time consuming process, especially if the parties are not cooperative or having a differing expectation. Challenges in enforcement. The lack of institution to oversee the process can sometimes more difficult to enforce the arbitral award. So yes, it is true. There are some disadvantages also in the ad hoc arbitrations. Greater need for cooperation. Success is heavily dependent on the parties' willingness to cooperate in agreeing the rules and procedures, which can be difficult when a dispute has already arisen. So, the arbitration is basically a dispute between the parties. When they are not in a flexibility, how can we expect that for them to have a greater cooperation, greater need for cooperations? So, when you are not flexible for the willingness to cooperate, willingness for dispute resolution on their own, how you can expect that cooperation for the dispute resolutions. This is also one of the timeline. Thank you.